Hi, guys, and welcome to Chapter 8 of our MDC criminal law course, where we're going to cover a topic called Crimes Against Public Order and Public Decency. Now, if you remember, what we've been discussing so far have been the two main different categories of crimes. And I told you that on the one hand, one main category of crime is called the crime against person. And within it, we talked about homicide, we talked about assault, battery, robbery, and so forth. And then we talked about a different category of crimes, which we defined as being crimes against property. And within that category, we talked about things like larceny, and we talked about things like embezzlement, fraud, forgery, so on and so forth. This chapter is a little bit weird. It's one of these chapters that uh, I did not learn when I was in law school. It's not covered in law school. It's not really even covered in for the bar exam purposes, from what I remember when I took the bar exam. And yet, it covers basically what are a series of misdemeanors that are still very common in criminal law. It's just that because they're misdemeanors, many times we in the United States don't pay them as much attention as we should for purposes of learning them. And that is the crimes against public order and crimes against public decency. Now, these crimes are going to be very tricky many times because frequently the way that they are used are going to present problems uh, regarding constitutionality. And the reason for that is because a lot of times these crimes uh, are unconstitutional. The laws that define these crimes are labeled unconstitutional, and we are back to square one, deciding whether the behavior that the law was trying to criminalize is really problematic or not. So while we're discussing each of these crimes, you're going to realize that some of them have no longer remained in our statutes. Some of them remain, but by a thread. They're hanging by a thread. And others absolutely do remain and are in no way found to violate the Constitution. So let's get to it. The first, we can, subpart within this chapter are crimes against the public order. And the first crime that we will find is breach of peace. Now, a lot of these crimes, I should clarify, they are hundreds of years old. Many of these crimes are very, very old. They come from England. They're part of our common law, but they're not necessarily as easy to enforce or even enforceable as they were hundreds of years ago. So breach of the peace is the first crime against public order that we're going to talk about. The textbook defines it as a willfully committed act that disturbs the public tranquility or order and for which there is no legal justification. Okay. Now, under common law, this would cover a lot of behavior, including behavior that would nowadays not be criminal. In fact, would be protected under the First Amendment Freedom of Speech Act, freedom of speech, for example. And because of this, breach of peace statutes are frequently going to be found to be unconstitutional. They're going to infringe on the right for people to peacefully assemble, which is part of your First Amendment rights, or they're going to be found to violate your freedom of speech rights, which are also in violation of the First Amendment. So part of the problem also is that sometimes they're too broad and they're going to outlaw behavior that is protected under the Constitution aside from freedom of speech issues and freedom of assembly issues. So breach of peace statutes are really for the most part, are going to be unconstitutional, but they are a historical crime. Another crime is called fighting words, right? Now, fighting words are words that the book defines them as words that tend to incite violence by the person to whom they are directed. We consider fighting words to be more like a slap on the face than a communication of ideas, and they are not protected by the First Amendment. The problem is that nowadays, trying to properly define examples of what constitute fighting words is a nightmare. It's almost impossible to figure it out. And uh, the Supreme Court almost never, ever really enforces fighting words uh, or words as being fighting words. So the fighting words doctrine, while it still exists, in my opinion, it's kind of hanging on by a thread because it's not really something that you see very frequently, if ever. And even though fighting words are not allowed, precisely defining which words fall under this category that actually rise to the level of a slap in the face to be called fighting words, it's almost impossible. The next category of crimes, still within crimes against public order, the third one that we're going to talk about, disorderly conduct, vagrancy, and loitering. Uh, Now, disorderly conduct was not something that would have been historically found in common law England, but disorderly conduct is defined by the textbook as minor offenses like drunkenness or fighting that disturb the peace or behavior standards of a community or shock the morality of the population. Now, there are statutes that are going to punish this type of behavior. Typically, what they're going to do is they're going to list examples of what constitutes disorderly conduct so that the statute itself is not overly broad or vague or prohibit behavior that's otherwise protected within the First Amendment. Now, very closely related to disorderly conduct is a crime that has been around for centuries, and that's the crime of vagrancy, very related to it. And vagrancy, the textbook defines as an act or condition of wandering about from place to place without any visible means of support, refusing to work even though able to do so, and living off of the charity of others. So, this is where you get, for example, the word vagabond. Vagrancy was when a person would go from place to place, refusing to work. The idea was that or society considers these people to be lazy. They didn't want to work. They just wanted to take advantage of the generosity and charity of others and just live off of people, moochers, so to speak. And this was outlawed for many, many years in England, centuries ago, but it was not resolved. And as the textbook mentions, most statutory vagrancy laws are unconstitutional and have been declared so because of how vague they are and the tendency that they have to discriminate against racial and ethnic minorities and poor people. Um, you know, you're going to discover that some of these statutes, vagrancy and others that we're going to mention, uh, could potentially criminalize homeless people or homelessness. And realistically, we shouldn't be punishing homeless people. Society, either through private organizations or the public welfare, should take steps to help people who are homeless. We shouldn't be trying to punish homelessness. So that's the definition of vagrancy. Um, some states modern states have used the term loitering instead of vagrancy. Now, uh, the textbook doesn't really offer a definition for loitering, but they do provide an example of an ordinance that outlawed loitering, where it stated that it is an offense to loiter in a place, at a time, or in a manner not usual for law abiding individuals under circumstances that warrant alarm for the safety of persons or property in the vicinity. So, what was loitering? Loitering was basically essentially to remain in any one place with no apparent purpose. And so, if you were in a space or in a position, in a location where um, you had no real reason to be just hanging out there, and it didn't seem like you were having any purpose for why you were there, that would have been considered the crime of loitering. Very related to vagrancy. Remember that vagrancy, though, um, was intending to criminalize people who purposely went around asking for money and, throughout the cities. Loitering is hanging out in a public place or in a public place in general for no apparent reason. Um, Now, loitering statutes many times have been used by police departments to try and regulate gang behavior. Gangs are many times those groups of people who are going to be up to no good in specific locations, and that's why cities have tried enacting loitering statutes. It's a very limited success because realistically, the problem with loitering is that we have the right to just hang out any public place, minding our own business, bothering nobody. Um, but there are some limited loitering statutes, particularly within Chicago, for example, um, that do not have or have not been deemed to have problems with the U.S. Constitution. But for the most part, loitering statutes are going to be very limited, very problematic, very troublesome. Um, we're also going to have obviously crimes like driving under the influence. By the way, uh, the state of Florida, if my memory serves correct, has not just um, laws that outlaw driving under the influence for motor vehicles, for cars, but also even things like bicycles. Uh, I believe Florida has a statute that criminalizes driving a bicycle under the influence of drugs or alcohol. And also, um, airplanes and boats and things of that nature. So it's not just limited to uh, cars or motorcycles, but it extends to other forms of transportation as well. And they have different names. The most common one is obviously DUI, but there's also operating under the influence of liquor, OUIL, driving while intoxicating. I'm sorry, while intoxicated, DWI, and unlawful blood alcohol level, UBAL. All of these are terms basically saying the same thing. You're operating a motor vehicle or operating a vehicle of some sort while under the influence of drugs and alcohol. And also, these are going to be um, criminally punished. Additionally, the sale of alcohol to minors is also a crime. Okay. Um, it is also illegal for minors to be in possession of alcohol. So it's not just the crime is not just limited to adults who sell to minors, but it's also illegal for minors to be in possession of alcohol. And minors is defined as somebody who is under the age of 21. In for this example, for this category. Moving on, still talking or still on the topic of crimes against public order. You're going to discover crimes. Unlawful assembly is another crime, and this is a misdemeanor that referred to what the textbook defines as situations where there was a meeting of three or more persons to disturb the public peace with the intention of participating in a forcible and violent execution of an unlawful enterprise or of a lawful enterprise in an unauthorized manner. In order for it to be labeled unlawful assembly, the group does not need to have carried out its purpose, but if it takes steps to do so, it commits a rout. And if it actually carries out the plan, it commits a riot. So um, that's unlawful assembly. Rout and riot, very similar. Rout is when they take steps to carry out the plan. Riot is when they actually correctly execute out the plan. Um, so that's a crime. Not necessarily common to see that term, but you'll see it somewhere. So that's another crime. Obstructing a highway or a public passage is another crime. Public authorities are going to have the right to regulate the flow of traffic and people on public highways, streets, sidewalks, and individuals do not have the right to block the access of law enforcement or of others to those public areas. Okay, so where it becomes problematic is, does it give police departments the power to ban outright demonstrations and protests? And the answer is no, especially like if they're not in sidewalks, but they will have some power or they will have power to regulate the time, place, and manner in which these demonstrations are done. And just because you want to have the right to demonstrate and protest doesn't mean that you have the right to go on 995 or I-75, shut down the highway, and impede public traffic. You could be criminally prosecuted. Animal abuse was a crime that historically was ignored in the past, but now is increasingly becoming more criminal. It's considered now, in law school textbooks as a crime. Animal abuse arises not just in the way people treat or neglect their pets or other animals, but also in the use for how human beings treat animals for research purposes. Okay, so one final crime against the public order is harassment. Now, harassment is very interesting to define. Sometimes states are going to define them based on, or they're going to categorize them by degrees, first, second degree of harassment. But really what you're looking at is the criminalization of harassment techniques like insults, challenges, phone calls, or other means of inciting an individual to violence, subjecting another to offensive touching, engaging in alarming conduct, or making repeated communications anonymously or at times or in places that are inconvenient to the recipient. So it's basically when you're bothering somebody repeatedly through insults, challenges, phone calls, and trying to get the person to fight, or if you're subjecting another person to touching that's offensive, it also might be battery, and engaging in really concerning behavior, or anonymously repeatedly communicating to somebody at a time and place when it's really inconvenient for that person to receive those calls or messages. So those are the crimes against public order, right? What they all have in common is that they really are crimes that influence negatively the public peace, right? There's no way around that. A separate category of crimes are crimes against public decency. Now, these crimes were historically going to be involving behavior that society considers to be morally reprehensible. Behavior that historically would be criticized and condemned by churches, and that society felt would be very negative for its citizens to engage in. Prostitution is one of them. And historically, in some places, prostitution was accepted as an inevitable, even essential practice in certain societies. However, critics of prostitution claim that it exploits women, and in some cases children, and it contributes to the spread of STDs. In the US, prostitution is illegal in all but some rural Nevada counties. So, how do we define prostitution? Well, the textbook defines prostitution as indiscriminate sexual acts for hire. While some state statutes specify women as the offenders, others include men. The criminal offense may include not only the prostitute, but any persons who solicit or promote the business of prostitution or who live off of the prostitution's earnings. All right. Pandering is a crime that's related to prostitution, and the textbook defines pandering as procuring or securing a person, usually a female, to satisfy the lust of another, usually a male, catering to the lust of another person, Uh, as the textbook mentions, this is basically what you guys know as pimping. So that's a separate crime in some states from prostitution. Some states just combine them, and it's all part of prostitution. Human trafficking, another crime, a very serious crime, very, very serious crime, um, where many people don't notice the seriousness of it. But it's a crime that is on the rise. Millions of people are subject to the pain and humiliation of human trafficking. It's not just necessarily limited for sex, but many times it's also about making people slaves, and really like a slave trade. There are modern day slaves, even though every country, to my knowledge, in the world has outlawed slavery. It doesn't eliminate the reality that in practice, some countries still allow or turn a blind eye to the practice of slavery. Uh, Crimes that punish obscenity, lewdness, and indecency. Um, these are crimes that are trying to prevent a variety of behaviors that people find offensive. Uh, they're very challenging to prosecute, and they're very challenging to enforce. Um, the Supreme Court specifically has had struggle defining obscenity. Originally, one Supreme Court justice, when trying to define obscenity, said they knew it when they saw it. And obviously, we cannot have a crime that is defined in such subjective terms. The textbook defines obscenity as written or visual material that is not protected by the First Amendment because of its offensive, clear description or depiction of sexual acts, because it lacks any political, literary, scientific, or artistic value, and because of its tendency to arouse improper sexual reactions in the average person. Uh, so that's really what obscenity is. Um, Fornication was a crime. Fornication referred to unlawful sexual intercourse between two unmarried people of opposite genders. This used to be a crime. It used to be a crime for people to have sex before marriage, and it was called the crime of fornication. Unlawful sexual intercourse between two unmarried people of opposite genders. Again, we're not talking about same sex, because that was a different crime altogether. That would have been the crime of sodomy. Adultery, on the other hand, was also a crime, and this was when a single person was involved in unlawful sexual intercourse with a person who was married to somebody else. Um, it is still a crime in many states, but realistically, they're very rarely enforced by prosecutors, right? You may encounter adultery issues or adultery becoming a bigger issue when you're discussing divorce proceedings. Bigamy, another crime against public decency, was considered a crime against the family, and the textbook defines it as an individual knowingly and willingly getting married when he or she is aware that that the person they're marrying remains married to somebody else. Okay? So that is bigamy. It was not a common law crime, but it has historically been criminalized in the United States. Pornography. It is not illegal for adults to have pornographic material. However, it is illegal to possess child pornography, because we consider that to be sexually exploiting children, and that's an evil thing. So Congress and many states have passed laws intentionally prohibiting and punishing child pornography. Sexting. Uh, Pretty controversial as to whether teenagers are allowed to text pornographic materials to other teenagers. It'll probably become a crime. It'll probably be a crime for an adult to receive and keep sexted materials. but it's very controversial how to engage in it, or how to punish this, and how to prosecute this. Revenge porn, something that all of you have to remember for the rest of your life. It is a new crime. It's a new pornography crime, but it is a crime that now pretty much every state has, or is in the process of having in their books. So this is when pornographic images are published without the permission of one of the subjects. The textbook says the example is that couples, some of whom may have met online, send digitally nude pictures of each other or send pictures of one to another, and somebody breaks up, and one of the people who got broken up publishes the nude images online to either a website or to other people. Revenge porn, that is a crime. That is a crime. Those of you that know of somebody who has broken up and has published sexual material that they had of their person they were dating after the breakup, that is a crime, and that is called revenge porn. And that covers the chapter. Let me know if you guys have any questions. If not, see you guys in a week. Stay safe, everybody, and goodbye.